To, to see so many folks interested in learning about the Second Amendment. We do ask that you please mute yourself throughout this presentation this evening, and we do need to inform you that it is being recorded. So I'm Vicki Paulison, and along with Christina Schlitt, we co-chair the Firearm Safety Network of the League of Women Voters of the state of Michigan. And for those unaware, the League of Women Voters is a nonprofit political organization that works to protect voters' rights and encourages informed and active participation in government. And throughout its 100-year existence, it has remained nonpartisan. The League influences public policy through education and advocacy, and one of our advocacy groups supports firearm safety. Firearm violence has become a public crisis in our country, and the University of Michigan's Institute for Firearm Injury Prevention provides some frightening statistics. We lose over 45,000 Americans each year to firearms. That's about 124 people dying from a firearm-related injury every day. 54% of those are death by suicide and 44 are homicides. And we have seen a 30% increase in that rate since 2014. And even more sadly, firearm injuries are responsible for 1 out of every 4 deaths among our youth population aged 15 to 24. In our own state of Michigan, we lost 1,544 Michiganders to firearm-related deaths in 2021. That's the latest year with available data. And every year since 2011, we have lost more Michigan residents to firearms than to motor vehicle accidents. But the encouraging news is that our Michigan legislators passed a number of bills this year aimed at reducing firearm violence. Background checks and safe storage of firearms are now required. And there is a gun ban for domestic abusers, and extreme risk protection laws are in place. But despite the passage of these laws, 45 of Michigan's 83 counties have passed resolutions identifying themselves as Second Amendment sanctuary counties. These counties prohibit or impede the enforcement of federal or state gun laws perceived to violate the Second Amendment. We've invited Michael Waldman, author of the Second Amendment, a biography, and his associate, Robin Sanders, to explain to us what the amendment means and doesn't mean. Now, in addition to authoring 8 more titles, Michael is a president and CEO of the Brennan Center for Justice and NYU School of Law. The Brennan Center is a nonpartisan law and policy institute that focuses on improving systems of democracy and justice. It is a leading national voice on voting rights, money in politics, criminal justice reform, and constitutional law. And Michael, a constitutional lawyer and writer who is an expert on the presidency and American democracy, has led the center since 2005. Prior to his position at the Brennan Center, Michael was director of speech writing for President Bill Clinton and served as assistant to the president from 95 to 99. He was responsible for writing or editing nearly 2,000 speeches, including 4 State of the Union and 2 inaugural addresses. And he was special assistant to the president for policy coordination from 93 to 95. And more recently, he was a member of the Presidential Commission on the Supreme Court of the United States in 2021. Now, Robin Sanders, his associate, is also with the Brennan Center. She is counsel with the Democracy Program's Voting Rights and Elections team, where she focuses on voting rights litigation and policy advocacy. And in September of this year, she co-authored a report called Guns and Voting. And she is familiar, has knowledge about Michigan, guns at voting and polling places. She will address that for us this evening. Now, if you have questions for Michael and Robin, please type them in the chat box, and Christina will make an effort to present them at the end of the presentation in our Q&A session. And it's my privilege now to turn the microphone over to Michael.
Thank you so much. It is wonderful to be with you. We always cherish our opportunity to work with the League of Women Voters all over the country. We have represented the League. We are allies with the League. in all the efforts we all make to make our democracy work. We really believe that we are in a great fight for the future of American democracy, nothing less, and that the stakes really are that high. Most of the time, what we all work on together are issues involving voting and redistricting and campaign finance reform and the health of our democracy. But we work broadly too on the Constitution, how it ought to be read, how the courts ought to deal with it, and how we can make it a document that works for our country going forward. Robin, as you heard, is a voting rights attorney and an attorney in our democracy program. And I'm going to take the brunt of the work here, focusing on and telling the story of the Second Amendment and how it got created, how we interpreted it over the years, what the courts have said now, and what the implications are going forward. I dragooned Robin into being with me here because I know she is such an expert on this particular aspect of voting and guns and the laws as they currently stand all over the country, including the fights that are underway in Michigan. So I appreciate, Robin, your work and your brilliant writing and advocacy and being here. Robin most recently spent about 3 weeks in Texas, where she and others from the Brennan Center were litigating against the egregious voter suppression law there. I believe with the League, but with certainly all the other voting rights groups and good government and civil rights groups. So as you heard, I wrote a book a decade ago now, came out in 2014, called The Second Amendment, a biography. And I wrote it at a time when we had just had the Newtown shooting, the school massacre in Newtown, Connecticut, which really brought the issue of guns and gun safety back to the fore of public consciousness. And once again, we were debating issues of public safety, issues of gun laws. At the time, there was legislation before the Congress on background checks that had a huge amount of momentum and support, although it was eventually stymied by the NRA and its allies. And it was noteworthy to me that it was the first time we were having a debate like that, first time these issues were so front and center, at a time when people instantly talked about the Second Amendment and talked about the Second Amendment as what they were really talking about. And I wanted to understand how that happened, because it's really an extraordinary new development. It is the product not of history, not of law, not of the Constitution, but of a multi-decade campaign to change how we saw the Second Amendment. And it's both important for us to all know in terms of as we think about our own work of how to make change happen, but also as we try to ensure that we can have sensible, common sense, evidence-based gun safety laws, which do not in any way, in my view, conflict with the Second Amendment or with gun ownership and responsible gun ownership. So the Second Amendment is very short. It's the shortest amendment to the Constitution. It says very simply, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. As you know, there's a bunch of commas in there, but you can sort of ignore the commas. They believed back then in freedom to punctuate. The rules had not been established yet. And that Second Amendment comes to us from a time that is almost unimaginably different from our own time in so many ways. What the Americans of that time, with the colonists who were becoming revolutionaries and then becoming the creators of the new nation, what they cared about was those militias. The militias are not like anything we have today. They're not like the National Guard. What they were was a universal military force. Every man from age 16 to 60, and eventually every white man, but at first it wasn't just white men, every man was required to be in the militia and required by law to own a gun and bring the gun to their militia service. The militias were how there were no police force, there was no army. Militias were used for everything from public safety to enforcing slavery to defending the frontier. And if you think about it, the colonists really cared about the militias. It was like the red, the Minutemen at Lexington and Concord, they were militias, and the redcoats were what were called a standing army. And they really feared having a paid professional centralized army. Well, the Revolutionary War happened. They discovered pretty quickly that the militias didn't work very well, and they actually created an army. And then they had to deal with the Articles of Confederation, which weren't working out very well. We were sort of a failed state. So as you know, they in 1787 they gathered in what became the Constitutional Convention, and the Constitution that was created emphatically created a strong central government, including having a United States Army, including the possibility of having an army. It did not ban having an army. It preserved the militias, but it made clear there was going to be a central army. And there was a huge, roaring debate over the Constitution and whether to enact it and whether to ratify it. And the people who were for the Constitution were called the Federalists. The people who were against the Constitution were called Anti-Federalists. And what the Anti-Federalists were worried about more than anything else was that it would create tyranny, that it would create a central government that was too strong. And one of the things they were really worried about was that the central government would crush the state militias, which they saw as bulwarks of liberty against tyranny. And so, in order to get
I'm just
Constitution,
signing into a
the
Zoom
constitutional
meeting
amendments
on
passed, and everybody
what
may
we
want
can do
to
improve
may want to
gun
consider
safety
muting
in
their
every.
Zoom. Thank you. To get the Constitution passed, over a lot of opposition, they agreed, well, we'll make some amendments. And so James Madison put forward what became the Bill of Rights in the first Congress as a bill of Congress passed on the floor of Congress. And we think of the Bill of Rights right now as kind of like the 10 Commandments. It's got its 10 things, and it's this very holy document. It was not like that at the time. Madison wasn't really for it. He was just doing it for political expediency, by and large. And they actually had 22 amendments in the original version he proposed, but one of those amendments dealt with the militias. And the Second Amendment was marked up in public, debated and written in public on the floor of Congress, just the same as if it was on C-SPAN today. And 12 members of Congress spoke, and not one of them spoke about the Second Amendment reflecting an individual right to gun ownership for self-protection or hunting or anything like that. It was just about the militia. And all the debate was whether there should be a conscientious objector clause, as Madison wanted, in the Second Amendment, so that people who were like Quakers didn't have to bear arms. And so they passed this, and it became part of the Constitution. And very quickly, the militia system fell apart. Nobody really wanted to do their militia duty anymore. So the question people asked for the longest time was, well, did the Second Amendment reflect an individual right or a collective right? And the answer was both or neither. It was an individual right to fulfill the duty to serve in this military force, the militia. The idea that we could go back in a time machine and ask the founders, ask James Madison what it is we ought to do, our questions would baffle them, and their answers would baffle us too. Well, pretty soon the militia system fell apart. It faded away. And over time, we had guns and gun laws all throughout American history. There were plenty of guns. People felt they had the right to defend themselves. This was not something they thought they were putting in the Constitution necessarily, but they thought it was from common law from England. But they understood that it was always, always, always a function of public safety, whether that was the militias or the many, many gun laws that existed in states and counties and cities all over the country. Some of my favorite facts about this, because it was shrouded in so much mythology, as you can imagine. In 1824, they created the University of Virginia, and the new Board of Visitors, the Board of Trustees of the University of Virginia, wrote the bylaws for the university. And there were 8 of them, and they voted on everything from, that graduate students could teach could teach large lectures, to all the rules about dormitories. And among the rules that this Board of Governors voted was guns were banned on campus, guns and swords. It was clearly about safety. And the people who voted for this included James Madison and Thomas Jefferson. They didn't think this violated their sacred right of gun ownership. Um, Another thing that was striking is that after, well, all throughout the 19th century, there were guns and there were gun laws. Even in the Wild West, there were gun laws, contrary to what you saw in cowboy movies. Dodge City, Kansas, it's kind of the archetypal Wild West gun, Wild West image. And there's a photo from 1872 in Dodge City, Kansas. And it looks like it's a movie set on the Universal Studios backlot tour. It's a dusty main street. There's saloons and hitching posts and all that kind of stuff. And there in the middle of the street is a sign. It says, "Welcome to Dodge City. Firearms strictly prohibited." And in fact, when you went to these towns on the frontier, you had to check your gun with the sheriff, and they would give you a token like you were giving a coat check. We had these kinds of guns, but plenty of gun laws all throughout American history. Including in the early 20th century when people crowded into cities like New York or Detroit, and there passed new gun laws to deal with the handguns and other things of that nature. And it was always assumed that you could have gun laws and gun safety. In the 1930s, when the first federal gun law was passed, it was dealing with the rise of bank robbers and people like Bonnie and Clyde and John Dillinger, and they were using the new technology of the getaway car, and they passed a law dealing with it. And the NRA testified, and they were asked by the members of Congress, can you think of any constitutional provision that might be affected by this? And they said, no, we can't think of any. There were very few Supreme Court cases on this topic because, again, it was understood that it was about the militias and that you could have guns and gun laws. And this was as settled a consensus as you ever found in American life. Well, that all seems like ancient history or fan fiction. It seems impossible to imagine. What changed? What changed was the role of the NRA. So the NRA, the National Rifle Association, was created after the Civil War. It was created by former Union officers who felt that their soldiers couldn't shoot very well, and it was for firearms training and safety. Eventually, it became really a voice for hunters and sportsmen, and it reflected kind of the rural gun culture, especially. But it was not a crusading organization designed to demolish all the gun laws in the United States. But in the 1970s, as happened with a lot of other mainstream organizations, it really was taken over by the right and lurched far to the right. They had something called the Revolt in Cincinnati. The NRA was so removed from politics that it announced that it was leaving Washington, D.C. and moving its headquarters to Colorado to signal how detached from politics it was. And there was a revolt at the annual meeting, and it transformed itself instead into an organization that calls itself the oldest civil liberties and civil rights organization in the country. When you go to the headquarters of the NRA, they used to have signs on the wall about firearm safety and training, and now they have the Second Amendment, but with the part about the militia just edited out on the wall. And they began a long crusade to change how the country and how the courts saw the Second Amendment and saw what it meant for gun laws. They started with, actually with scholarship. They paid a lot of money to professors to write articles and do studies. Some of it was entirely made up. Some of it was valid. It began to build momentum. They got very involved, as you know, in politics in places like Michigan, but all over the place. Bill Clinton, I was Bill Clinton's chief speechwriter, as I think you heard at the beginning. When the Democrats lost the House of Representatives in 1994. Bill Clinton blamed the NRA because there was a gun safety bill at the time, and they retaliated against and voted a lot of the members of Congress out of office. Um, they worked to change public opinion so that over time, the idea that the Second Amendment reflected an individual right to gun ownership was understood and accepted and believed it by more and more of the public. And only then did they go to court. And I should have mentioned this at the very beginning, because this is kind of the mind-blowing fact. The Supreme Court did not say that the Second Amendment reflected an individual right to gun ownership until 2008. That was the first time. That was the case called DC versus Heller. And it purported to be originalist. It purported to be talking about the original intent, but it was really recent. And as I've just described, it kind of really mischaracterized the actual history of the Second Amendment and the actual history of the history of the country in some ways on guns. So Heller was in 2008, and there was another case 2 years later that applied it to the states. And it was a judicial earthquake. It was a really big deal for them to proclaim that this was an individual constitutionally protected right. It never happened before. But it had a less significant impact, in fact, on gun safety laws and gun safety all over the country. Gun rights advocates, the NRA and others, challenged dozens and dozens and dozens and dozens of gun laws and brought dozens and dozens of lawsuits. And judges said, well, it's an individual right. They took it very seriously, but that right could be balanced against the public's right, could be balanced against public safety. And so in about 90% of the cases, the gun laws were upheld, despite the challenge from people saying they violated the Second Amendment. And there was a considerable effort to get loosening of gun laws and gun safety laws all over the country. This was not done through the courts, but through, again, political action in state legislatures. But in terms of what the Second Amendment meant, the courts were very clear all over the country in hundreds and hundreds of opinions that you could have an individual right, you could have a right to gun ownership, but you could still have sensible, strong gun safety laws. And the Supreme Court stayed out of it. As I said, this was from 2008 on. For the 12 years after the Heller case, the Supreme Court of the United States let this approach become the way the country regulated guns. Well, what changed next was the composition of the Supreme Court and nothing else. We now have in the U.S. Supreme Court a supermajority of 6 very conservative justices working in lockstep, marching in lockstep, all of whose nominations were backed by the NRA, and all of them were appointed by presidents whose election was backed by the NRA. The NRA made its biggest ever political expenditure on behalf of Donald Trump, who, as you know, appointed 3 of the 6 justices on the court in this supermajority. And having this consensus of how to regulate guns with individual rights, but also gun safety. In 2022, the Supreme Court heard and ruled on a case called Bruen. And I wrote about this in my most recent book, which is called The Supermajority, about how the Supreme Court divided America. And the Bruen case was something very different from Heller. So the Heller case was written by Antonin Scalia, very conservative. He was very proud of relying on the original intent of the founders for what he was doing. Scalia was once asked, what's the difference between you and Clarence Thomas? And Scalia said, well, I am an originalist, but I am not a nut. Heller was written by Scalia. Bruen was written by Clarence Thomas. And it is by far the most extreme Second Amendment ruling in the country's history. It is breathtaking in its impact. It struck down the gun law of New York State, the law passed in 1911 saying you can't carry a gun around New York City, basically. And that affected 6 or 7 other states that had similar laws. But its impact was really much bigger than that, because what it said was that the only way a gun law could pass constitutional muster, the only way it could get through the Second Amendment, was not based on public safety. It said you could not consider public safety, contemporary public safety concerns, in assessing the constitutionality of a gun law. What it said you had to do was look at, quote, history and tradition. Basically, was there a law back then? Was there a law in the 1780s and 90s? That was the same law, in effect, as the one being considered now. They also looked a little bit at the period of the 14th Amendment. After the 14th Amendment came after the Civil War, when there was terrorism against Black citizens in the South, and when the Ku Klux Klan and others were terrorizing Black citizens, one of the intentions of the 14th Amendment was to enable Black people to arm themselves in defense. So they looked at that too. But basically the idea was, did you have that law back in the 1791? And the results have been just as remarkably almost satirical as you could imagine. In Western New York State, a federal judge New York passed a new gun law. After its gun law was struck down, a federal judge said, well, history and tradition. 2 examples from the colonial era, that's a mere trend. For it to be tradition, you need 3 examples. And this judge said he could find no tradition of laws banning guns at sleepaway summer camps in 1790s. Therefore, it was unconstitutional to have them now, let alone laws banning guns on subways, which had not been invented, were not going to be invented for 100 years. There were cases like this all over the country. Gun laws are toppling like bowling pins. Now, not all of them, but a lot of judges have ruled this way. The most egregious example of this, probably, is something that you may have heard of in a case. It came up to the U.S. Supreme Court a couple months ago in a case called Rahimi. And the Supreme Court actually took this case just 2 years after it had made this big ruling in Bruin, maybe because they realized what an extraordinary mistake they had made. We'll see. The Rahimi case said, and it's from Texas, it's from this very conservative federal court in Texas. The Rahimi case said, well, the law, the federal law, the longstanding federal law, taking guns away from people with adjudicated records of domestic violence was unconstitutional. Why? Because back then, hey, that wasn't illegal, wasn't a problem. It was a feature, not a bug. And this was so horrific a ruling that the Supreme Court took the case. And I think there's a decent chance they're going to try to pull back on it, at least somewhat. So we have an unsettled doctrine right now of what the Second Amendment means, because the ruling in Bruin was so extreme that it makes it hard to pass almost any gun laws. Or you never know if some judge somewhere is going to say, oh, well, there's no colonial, the colonial regulation from 1791 that's like this. I have a feeling the Supreme Court is going to try to clarify that you could still have laws that take away guns from especially dangerous people that are more rational. We'll see. That would be a big retreat if they did that, cleaning up a mess they made. So what is the consequence of all this? It is still the case that gun laws are constitutional, and that the Heller case in particular indicated a whole range of laws that could be constitutional. And the Bruin case sort of in effect copied what the Heller case had said. And it says that you can keep guns away from unusually dangerous people or in unusually sensitive places. And so the kinds of things that the Second Amendment sanctuary idea, the Second Amendment counties, what those counties say is, and it's not just in Michigan, say, oh, any gun law basically of any kind violates the Second Amendment and we're just not going to enforce it. That's illegal. State law and the federal law supersedes the whims of a county. And if a law is legal and constitutional, and if a court upholds it, then it has to be enforced. And if it's not going to be enforced by the county, well, it could be enforced by state government or by the federal government. In fact, it's more of a press release than anything else, but it's very worrisome. It's a real challenge to our whole system of government. And you can imagine all the ways that liberals would use this kind of thing. It's a terrible precedent in a lot of ways. One of the ways that gun laws are emphatically still allowed is that both the Bruin case and the Heller case before that said that elections, polling places are the kinds of sensitive places you can prohibit guns for all the reasons you can imagine, the potential for violence, the challenge to democracy that would entail. So such laws really are constitutional. However, the chaos in the courts and the rapidly changing role of the Second Amendment and the simple profusion of guns. We now have many more guns than people in the United States, and sadly, about twice as many gun deaths as auto deaths in the US right now. About 40,000 gun deaths, about 20,000 auto deaths in a given year. All of that means that the protections are not there that we need on guns and elections. And on that note, I'm going to turn over to Robin. Before I do that, I'll just say again, I think this issue has mobilized many people. It's really, these mass shootings take up all of our attention, but it's the everyday gun violence on the streets of cities and rural areas, the suicides that are more damaging than even these big mass shootings. We need, as a society, I would say, to find a way to once again understand you can have individual rights, you can have guns, but you can have gun laws and gun safety. Gun laws and gun safety, firearms and protection and freedom all go together. And that is the true story of the Second Amendment, not this kind of NRA cartoon that is so easily pushed out. But Robin, why don't you talk a little bit, if you could please, about this particular topic of guns and elections and voting and the kinds of things we're hoping people will look at doing.
Sure, and thank you so much for that really wonderful talk, Michael. As Michael was saying, we believe at the Brennan Center in protecting our democracy. And so as a result of the proliferation of guns, we understand how that's intersecting with one of the cornerstones of our democracy, which is voting. And we believe that no one should ever have to worry about encountering a gun while they're participating in this important civic function. But currently only 12 states and Washington, D.C. currently prohibit and ban firearms, open and concealed carry at polling sites. And so I was a co-author of a report that we joined, that we co-authored along with the Giffords Law Center. And my colleague, Sean Morales-Doyle, was the other author from the Brennan Center, a report titled Guns and Voting that we released in September of this year, where we discuss how it shouldn't be controversial to enact laws that ban guns wherever votes are being cast or voting activity is taking place. As Michael just discussed, the Supreme Court's Bruin decision was the most significant expansion of gun rights in our nation's history. And as a result of that decision, countless common sense limitations that had been previously placed on firearm possession across the country have been wiped out. But one of the key and important features of that decision is that although it's the most overreaching Second Amendment opinion that's ever been issued, there was clear language included in that opinion that that signaled that the court said that these places have historically been understood as being allowed to ban firearms. And the court terms these as sensitive places. And although the court didn't actually present a precise definition of what sensitive places are in the Bruin decision, it does specifically enumerate legislative assemblies, polling places, and courthouse as examples of locations that have historically understood to qualify as sensitive and that are, therefore subject to permissible limitations and state regulations on firearm possession. And so in our report, we survey the history of the Second Amendment, as Michael has brilliantly done for us tonight. And we make our way all the way up through the Bruin decision, which was handed down 2 terms ago. And ultimately what we do in this report is that we make policy recommendations for states to strengthen or fill the holes that currently exist at federal law. So there is no federal law that bans guns at polling places, which is why it's important that states act to fill that void. And so in our report, we make several recommendations, including that all states should ban open and concealed carry at polling locations and anywhere that is polling location adjacent, meaning anywhere that voting activity is taking place or the democratic process is taking place. Another feature of our report is that we also suggest that states should go further than federal law does in strengthening their anti-intimidation laws. And so it is illegal in all 50 states to intimidate or to engage in voter intimidation. But what we recommend in our report is that states actually go further than federal law, because again, the federal law just represents the floor, and states are empowered to expand rights beyond those that the federal constitution or that federal law grants to its citizens. And so what we recommend in the report is that states pass a law that would make it presumptively intimidating to possess a firearm wherever voting activity is taking place. And several states have legislative sessions that have been on the horizon and that are on the horizon within the next 2 years. And we believe that these states can act swiftly to enact these proposed laws. Some of them we're hoping that we can get passed before the 2024 election. But even if we don't, we still nonetheless believe in the importance of having this legislation passed everywhere that it can, including in Michigan. And so some of you on the call might know that the Michigan House of Representatives passed 2 bills to safeguard voters, poll workers, and polling places from gun violence in November last month. One of the bills would ban guns at or near polling places, early voting sites, ballot drop boxes, and the other would ban guns where absentee ballots are counted. The bills did not, unfortunately, the bills didn't make it out of the Senate. So if the bills do become law whenever the legislature resumes business, Michigan would join 18 states and Washington, D.C. as being places that currently, or jurisdictions rather, that currently prohibit open carry at polling sites, and 8 states and Washington, D.C. that currently ban open carry at drop boxes, as we've identified in the September report that I just mentioned we released. And so we applaud the Michigan House for taking action to keep guns away from voting and election administration. And we think that, again, most states lack this basic protection for voters and election workers from gun violence at and around voting sites and counting sites. And we think that the votes by the House represent and show that Michigan lawmakers are moving in the right direction with trying to pass common sense legislation to protect voters and election workers. And my colleagues and I have also begun delving into research to determine how strong we think the law is as a constitutional matter. And based on our research so far, we do think that the proposals that we make in our report stand on strong constitutional ground and footing in light of the Supreme Court's decision in Bruin, as Michael mentioned, because of the language that it includes, suggesting that polling locations are examples of sensitive places, but also because we think, at least based on our preliminary research, assuming that the Bruin test is not clarified in the Rahimi case, which we hope that it is, but assuming that it's not, we actually do think that there's historical support for legislation that would ban or prohibit guns while democratic activity is occurring, and that it would be sufficient under at least what most lower courts are understanding the Bruin test to require at this point. And so, we think that this is, again, in Michigan, a really good opportunity for Michigan to take the next steps to do what we think is critical to protect voters and election workers. And so, I'll wrap up by just saying that the bills are on ice, but they're not dead. The legislature is currently in recess until early January of next year. And next year will be the second year of the 2-year legislative session, and bills from 2023 can be considered next year. So in theory, this Michigan Senate could take up the two bills. And I'll just let everyone know on the call, it's House Bill 4127 and House Bill 4128. So theoretically, the Michigan Senate could take the pair of legislation up in January. But, you know, based on some discussions that we've had with our coalition partners, we still have some work to do to get them passed out of the state Senate. So I would really encourage everyone in this call who clearly, you know, finds this to be an important topic and understands the importance of keeping our democratic sanctuaries free from gun violence, to call your representatives, call your senators, and to encourage them to make this legislation law in the state of Michigan. And thank you again for having us on this call tonight. And we're happy to, I'll pass it back to whomever, but we're happy to take questions on anything that we've discussed. But thank you.
Thank you, Robin. We do have a couple of questions here related to the NRA. Given the first one is, given the profound effect of the NRA has had on proliferation of gun ownership, is there anything that can be done to curtail them? Probably Michael.
Well, there's an aphorism attributed to the philosopher Eric Hoffer, who said that every great thing start out as a cause and end up as a racket. And it started as a cause, become a bureaucracy, and end up as a racket. The NRA is an organization, as you all probably know, that has been beset by all kinds of legal challenges, claims of misconduct, all the leaders of the NRA suing each other and that sort of thing. It seems as though, in some respects, its claims of membership and other things are overblown. Nevertheless, its impact continues because the politicians that it backs are in office very frequently, and because the doctrine they've put forward lives on in the lifetime appointments of Supreme Court justices. So I don't want to minimize its impact, even as the ranks of gun ownership shrink in this country. The sort of cultural base of gun owners, which is basically by and large, you know, older white men like me, and rural people are shrinking, or as a share of the country. But the power of the NRA continues, especially through the courts. I think that the way, so there are legal things with you know, the investigations, and Tish James, the Attorney General of New York State, for example, has brought a very effective legal action against the NRA. But the main way the NRA is going to be undermined is political action and organizing and public opinion. The NRA and other gun rights activists don't. They have their power because they're so single-minded, because they grade these legislators according to their scorecard and only on that issue. And I'm not saying that we should do the same, because we all have many different concerns and many issues. But they have their power because of the intensity of their focus. I do think in the decade since Newtown, and you've seen the rise of groups like Everytown, which is funded by Michael Bloomberg, very effective. Moms Demand Action. You have freshman member of Congress, Congressman Frost, who's a young gun safety activist who was elected in Florida. This is becoming something. For a long time, politicians stayed away from this issue because they had this muscle memory of the power of the NRA. I do think that has changed. And don't forget, Congress did pass bipartisan gun safety legislation in 2022. It wasn't everything anybody wanted, but it was opposed by the NRA, and it was a bit of a political breakthrough.
Thank you. We have another one related to the NRA. Polls show that public opinion strongly supports many gun safety policies, background checks, etc. Why are so many congressional members still in the thrall of the NRA rather than reflecting the opinion of their constituents? Is it just money?
Well, I don't think it's campaign contributions. I mean, I think there's some of that. And as I said, the NRA's biggest single expenditure ever was on behalf of Donald Trump in 2016. but I don't, they don't give nearly as much money as many other interests do. It's the intensity of their support. It's the passion, frankly, of their members. And so I think sometimes people say, oh, they're really just a front for the gun industry. I just think that's far too facile. I don't think that's really true. The point though about public opinion is really right. That background check bill that I mentioned was being debated on the floor of the Senate a decade ago when I wrote my book. It was called Manchin Toomey. It was Senator Toomey, who was a Republican, and Senator Manchin, who was a Democrat then. But from West Virginia, you know, a pro-gun rights state, and that was for stronger background checks. And it had 90% support from the public. And that level of support has continued. The day the Bruen decision was issued, Gallup had a poll show in the wake of a lot of the mass shootings that were happening that season. And it found that everybody wanted gun laws to either be strengthened or stay the same. Only 8% wanted them loosened. And the Supreme Court, of course, radically loosened them. It was a position taken by 8%. So I think it's both the intensity of the NRA and the various ways which we all deal with, in which our system entrenches the power of minorities, of organized, often well-funded minorities, to block the will of the broader public. We know all about that in our voting work. We know about that when it comes to gerrymandering and the way that these state legislatures are locked into place by gerrymanders. And even the Electoral College. I noted in my book on the Supreme Court, and this is we have now, not now, the Supreme Court has lifetime terms and not elected members. And every other constitutional court in the world and every state Supreme Court has some kind of term limit. But we have lifetime terms. And one of the consequences of that is that in 7 of the last 8 presidential elections, one party, the Democrats, won the majority of the popular vote. That is the longest winning streak in American history for a political party in the popular vote. And the other political party appointed 6 of the 9 Supreme Court justices with lifetime tenure in making our gun laws. So there's a lot we need to fix in our democracy. If we fix our democracy more broadly, all the things you all do, all the things we work with you at the Brennan Center to do, we are far more likely to have better laws, whether it comes to common sense gun laws or reproductive rights or civil rights and racial justice or all the other things we care about. The will of the majority is a better gauge of good policy than the entrenched interests of the minority as reflected in our political system.
And I just want to add to what Michael is saying. I agree with everything he said, and just to piggyback off of what he was suggesting about public opinion and outrage, I do think that the public clamor after the Bruen decision is something that I hope is on the justices' minds as they're deciding the Rahimi case, because in that case it would lead to, again, earth-shattering consequences, because in that case the Supreme Court is tasked with deciding if federal law prohibits the possession of firearms by people who are under domestic violence protection orders and whether that's constitutional. And in that case, it's an adjudicated domestic abuser. And so I think that, and one other thing that I wanted to add about that case is if you take the time to listen to the oral arguments, the litigants in the case, particularly the government's attorneys who are asking the court to uphold this law, are asking the court to clarify their test in Bruen. Because they specifically stated at the oral arguments how much of a mincemeat it's creating in the lower courts, because as Michael mentioned during his talk earlier, it's creating such inconsistent opinions all over the place because of individual judges determining what is a sufficient historical analog to a challenged gun regulation. And so it's going to be very important for both of those reasons, not only the consequences of suggesting that adjudicated domestic abusers, it's unconstitutional to strip them of firearms, but also for the court to take the time to clarify what the test is in Bruin and to give some better direction to lower courts about how they should go about evaluating the constitutionality of firearm regulations moving forward.
And one of the questions in the chat asked about Roberts and Kavanaugh. They, in the Bruin case, they signed on to the 6 votes of the Thomas opinion, saying you couldn't consider public safety, only history and tradition. But simultaneously, they also had wrote what's called a concurrence, that's sort of their own views, which didn't say that. It said, well, the problem with the New York law, it wasn't objective in its rationale, in its reasoning. Well, that, you know, that made no sense. I mean, it's not as though the gun laws of 1791 were necessarily objective. But if Roberts and Kavanaugh wanted to take a better approach, combined with the 3 dissenting justices, who we don't know what Justice Jackson's vote would be, but she replaced Breyer and Kagan and Sotomayor. Well, then that's 5 votes for a different approach. I don't think it very likely that Gorsuch or Thomas or Alito are going to change very much. But the implications, both, as Robin said so brilliantly, the chaos in the courts that have been caused by all the inconsistent rulings, one judge saying you can bring guns to church, another judge saying you can't, that kind of thing, combined with the revulsion that people have over the Rahimi case and what it implies, maybe we'll put enough pressure on the court to get them to pull back a bit, at least to give some clarity. And so many of the gun laws, so many of the things that are positive around gun safety are things that really shouldn't fall foul at all of the Second Amendment. You know, one thing that's noteworthy is there's been almost no technological advances when it comes to firearm safety. When you think about cars, you think of all, it used to, you know, I said that guns killed twice as many people as cars in the United States. That was not always the case. It used to always be the opposite. Well, what changed? What changed was seatbelt laws and airbags and speed limits and things like that that were controversial when they were put in place, but which have made cars much, much safer. And none of them banned cars. People did actually argue that you had a constitutional right to drive and to have no limits, no speed limits, but nobody banned cars. And instead, what you had was technological advances, and guns have not had that. And if there's a breakthrough, it will come, I suspect, from the technology as much as anything else.
Thank you. We have another question. Why can't historical law or legal precedent be used by the Supreme Court justices to contradict the most recent competing historical interpretation written by Thomas in 2020?
Well, this is a big topic, and Robin and I could go on and on about this. So first of all, Thomas's history was wrong. He stopped well before 1911. The law that they struck down in the Bruin case was from 1911. Now, to me, that's history. That wasn't yesterday. That was a long time ago. And again, there has been a long, long history of gun regulation, especially when it comes to carrying weapons, which is what that case was about. There's much more of a tradition of people having their gun in their home to protect the home, but carrying weapons have been regulated or banned all along. So a lot of times the history is just wrong, and it's wielded for ideological purposes. A favorite insight on this is that in Heller, Scalia said, well, bear arms, what does that mean? Well, I'm going to pull out dictionaries from the 1700s. Bear means carry, because you have to be able to carry your weapon. And so therefore it had to be small enough to bear and to carry. And so therefore that means you should have the right to a gun, the right to a handgun. And a bunch of professors at Brigham Young University, which, as you can imagine, is pretty conservative out in Utah, they created a computer database that where they put all the writings from the founding era into this computer. And that way you could push a button and it would tell us the right answer. It would enable us to go back in the time machine and just push a button. It would tell us the right answer. Now, I think that's an absurd way to run a country and an absurd way to run a constitution. But anyway, they did that and they pushed the button and said, what does bear arms mean? And it said, bear arms means serving in the military, it was a term of art meaning serving in the military, such as serving in a militia. It didn't mean carrying weapons or having the right to a weapon. It was about serving in the military. So one problem is the history is just wrong and wielded for historical purposes, even when the history supports strong gun rules, such as carrying weapons. It just gets ignored on ideological grounds. Where I think there's a bigger challenge, I would argue, and Robin may have a different view on this. I don't mean to put her on the spot. I think that the project of trying to interpret the Constitution through this originalism is a very bad idea. It basically says, and we saw this not just in the Bruin case, but in the case that was decided the next day, which was the Dobbs case, the idea that you will only protect rights based on history and tradition basically says that we in 2023, this diverse, growing, changing country, that we need to be governed by the social views of property owning white men from the 1700s. That's crazy. We know, of course, that this was when women could not vote, could not own property, could not sit on juries, when Black people were enslaved, and on, when leeches were used for medical care. The idea that that's how we would govern our country now, to me, it's a dangerous game to try to beat the originalism with better originalism. Having said that, we at the Brennan Center have assembled historians, the top historians in the country, both to critique this approach, but also when necessary to show what the real history is. But Robin, what do you think of this?
No, I agree with you. I think that the Originalist project is largely a disaster. And, you know, I think, again, I keep going back to the Rahimi case because I do think it really does dovetail nicely with the Bruin case, at least as it relates to what the appropriate test is. But I think, again, in that case, the absurdity of viewing the constitutionality of certain gun regulations through an originalist lens is really on display in that case as well. And, you know, in some of the amicus briefs that were submitted in that case, you see the issues with that, as Michael suggested and highlighted, you know, chief among them being how women were viewed at whatever period in history that you want to go as far back as the court is going to go, and how it was honestly accepted and encouraged in many cases for women to be, you know, abused by their spouses or significant others. And so the idea that because there would be no law on the books at or near the founding that would suggest that if you were a domestic abuser, you should have your, you know, you shouldn't have your gun rights stripped, is absurd, because of course not, right? Because the history shows that at that time, women were not seen as equal citizens. And in fact, men were empowered to do precisely that. And so I think I agree 100% with what Michael says. And, you know, again, I think, you know, we're very excited at the Brennan Center for the Historian Project to be able to really counter the originalist narrative and to understand that there are other ways to interpret the Constitution that don't involve, as Michael suggested, what did a bunch of old white guys wearing wigs who didn't think women and African Americans were citizens under the Constitution thought about something. And so, you know, hopefully what we'll see in the Rahimi case is the court, you know, of course, I don't mean to suggest that I think that the ultra conservative wing of the court is going to somehow abandon their originalist viewpoint. But I guess what I'm suggesting is I hope that there's somewhat of a retreat from seeing that as the ultimate or way of testing or evaluating the constitutionality of firearms regulations, and seeing in that particular case in Rahimi with the facts that are presented, how that can lead to truly absurd consequences, and how that test really needs to be reined in and clarified so that it doesn't do so.
Thank you. Robin, with that then, what tests must be met to be able to establish state gun safety laws?
Yeah, so currently as a result of the Bruin decision, courts, as Michael said earlier, they can no longer balance the right to own a gun against the contemporary needs of public safety. And so now gun restrictions are held constitutional only if they align with this history and tradition of firearm regulation. And so at least as it stands right now, most courts understand this test that was adopted in Bruin to require courts to evaluate whether the challenge law burdens the Second Amendment's individual right to keep and bear arms. And so if the court determines that the answer to that question is yes, then the court must proceed to find whether or not there is an analogous law to historical restrictions. And it's not clear what the historical reference points are, and the relevant, under the relevant standard. But in Bruin, the court examined laws from the 17 and 1800s. And so that's what most courts have done, is to look back to that time period to determine whether or not it's a sufficient historical analog to establish that the law is constitutional under the Second Amendment. But as Michael also said, it's really leading to some truly absurd analytical reasoning. As he said, there was one judge who said, well, if it's only, there's only 2 laws that seem to be an analog to the challenge regulation, that's just a mere trend. There needs to be 3 to establish tradition within the meaning of the Bruin test. And then, as Michael also said, you've got other courts who are completely excising multiple points of history that should be relevant to the analysis. For example, there's the Reconstruction era, like that's a very important era. And it seems to be one that's completely out of the minds of most courts these days who are evaluating these laws under the Bruin test. So, that's currently where, most courts are with trying to interpret and construe what Bruin requires. But as Michael said, we're hopeful that in the Bruin case, in the Rahimi case, the court will clarify this test. And hopefully that means, again, telling us what is the appropriate historical reference point, how many laws in history need to have been similar to the challenge law for it to be constitutional. Even in the oral argument in the Rahimi case, you had some of the litigants saying to the court, it shouldn't be that it needs to be a dead ringer, meaning an exact replica of the law that's being challenged in order for it to pass constitutional muster. And so, we're hopeful that there's some clarity that's provided, because it really truly will have devastating consequences if these courts are permitted to continue reaching these inconsistent decisions. And I think, Michael, you probably want to add to that.
Oh, no, I think you're exactly right. I think, we'll know a lot more in a few months. By next June, probably we'll have a much clearer sense. And I hope that the search for a dead ringer is something we can end, and at least look for some of the principles of public safety and freedom and balancing them that were behind the gun laws from the beginning. One of the points we make as we do our work with history and historians is that history didn't stop in 1791 or even in 1868. The 14th Amendment, which is that was what happened in 1868, superseded the previous Constitution. It was a second constitutional revolution, and that gets ignored enormously. And they were aiming on issues of racial justice and so many other things for a much more equal society than was envisioned in the original founding. It was the second founding. So we'll know a lot more. And Robin, I do have to just give you extra props for your brilliant answer and poise with a very adorable research assistant trying to get in the picture. So we see your friend there, and it's okay.
The puppy. We have another question. Currently, the gun industry is generally immune from lawsuits, PLCAA. How does that impact efforts to reduce gun violence?
Robin, I can take that, or I think it's quite significant.
Sure, you can take that.
Yeah, no, it's again, it's not the Second Amendment. It's the cowardice of the politicians, and that's an example with the campaign finance laws actually do make a difference, because that was the firearms industry as much as the NRA. We all know that major corporations that have abused power or have hurt the public, one of the ways they've been curbed is through lawsuits. That is one of the things that changed the tobacco industry so significantly, was not just federal warning labels, but significant significant litigation, as well as by attorneys general, but by private parties. And, this country has taken a real turn for the better, in my view, in pulling away from the amount of tobacco smoking and the cancer and the dangerous deaths that occur. Those kinds of lawsuits are really important to police products in the marketplace in all different kinds of ways. And there's a law immunizing gun manufacturers and gun practices from these kinds of product liability and other litigation. I think it really hinders things, and it hinders the technological developments that I described. If you had the risk for gun manufacturers of their products being deemed too dangerous or negligent, or that they could too easily fall into the wrong hands, then you'd see more technological advances, such as smart guns, that basically you can't turn on your cell phone without putting in a code or a facial recognition, but you can pick up a gun. And if there were stronger gun laws through the courts, through lawsuits, you would have guns, you would have people having their right to bear arms, but you would have much safer guns and many fewer suicides, for example.
And talking about voters, where do youth voters fit into changing the climate?
I think it's a real bright hope. You look at after the Parkland school shooting, you had demonstrations and rallies and political movements all over the country. I mentioned the youngest member of Congress, I think, is Congressman Frost. Robin, is that right? And he came into this at age 20, was elected at age 24, I think, as a gun safety activist. I think younger people seeing the cost and the toll, not just on the streets and in their lives, but these are people who grew up having to do active shooter drills in schools, which is traumatizing. And I can barely imagine that. So I think there's a generational change. Again, the demographic group that wants no gun laws is a shrinking group. But they have a lot of power, and they're entrenching their ideas in the system. But Robin, do you agree that younger voters and younger people have a somewhat different view on this?
No, I tend to agree with you, and I think I would just add that I think youth voters are becoming especially attuned to how lobbying at the state level is critically important, as we see the federal landscape, changing in ways that some would say are not as favorable to their political views. And so I think, agreeing with what Michael said, I think another thing that at least I am seeing, or at least the sense I'm getting from youth voters, is that they really are seeing the importance of trying to lobby their state representatives to pass laws at the state level, or to amend state constitutions to grant greater protections of rights than does the federal constitution, and to take their fights to state court, because they may see that the federal court landscape is not a favorable one as it relates to many of these protections, including Second Amendment rights. So I would agree with that. And I think, as Michael said, I think it's just important to continue to make sure that people are aware of what's going on, so that they know the issues, and so that when it does come time to vote and to make your voice heard, that the next generation of voters is equipped to do that.
And Robin came to the Brennan Center after, among other things, clerking on the North Carolina Supreme Court. She understands that so much of the action takes place not in Washington, which is toxic and dysfunctional in the best of days, but in the states, which have their own problems, of course, but where you can get things done, and where sometimes the system actually works.
And there's
so I have time for only one more question. I apologize.
Okay, we have one more then. Underfunding of the Bureau of Alcohol, Tobacco, and Firearms and Explosives is a big problem in this person's opinion. Do you see that changing in the near future? How about removing constraints like no digital firearm registry?
Yeah, there's been a real war on that kind of law enforcement for a long time. I remember President George H.W. Bush resigned from the NRA in 1995 when it referred to BATF as jackbooted thugs. There's been a real effort to demonize the ATF, and as we see now, increasingly to go after all other kinds of law enforcement and the Justice Department itself, because when it holds accountable potential lawbreakers who don't want to be held accountable. I would have to say, unfortunately, the answer here is that while the House of Representatives is controlled by the current majority and Speaker Mike Johnson, who's the most extreme Speaker of the House on the right, I would say, in American history, exceeding even Newt Gingrich or any of the others, I don't think it's very likely that Congress is going to change the funding in a good direction for alcohol, tobacco, and firearms. You know, that's the kind of thing that you need the stars to all align very much, and that doesn't happen very much. We have, for better or worse, in our country, we're very closely divided. We've had divided government most of the time for the last half a century. And so funding for ATF, like for the IRS and other government agencies, becomes a political football.
Thank you. And with that, thank you both for your time and your valuable information. And with that, I'm going to turn it over to Vicki Paulison again to close out this program. Thank you.
Yes, Michael and Robin, that was very enlightening. You know, you mentioned, Michael, the fact that death by automobile fatalities has dropped dramatically and the tobacco industry has been curtailed. And both of those were in part public health issues, and they were tackled by a multi-pronged approach, which is how the University of Michigan's Institute for Firearm Safety and Injury Prevention is talking about this problem as a public health crisis. And they're going to be multi-pronged approach to help reduce that. And we are very grateful for the role that the Brennan Center is playing in that, and in the fact that you're working so hard to protect our democracy. So we appreciate you both here tonight, Michael and Robin, and we appreciate all of those who attended tonight. We also want to invite you to look at our website, which I'll put in the chat box if anyone wants to attend any other of the firearm safety events that we have scheduled. And with that, I'm going to say good night.
Good night, and thank you to my colleague Robin. I think you all can see how lucky I am and we are to work with such brilliant colleagues with so much ahead of them.
Yeah, thank you so much, and equally lucky to be shepherded by a wonderful president, Michael, and who's so knowledgeable about these topics. So thank you for having us.
And good luck to all of you.
Thank you.